we are digging into a legal thriller, really. It's the Supreme Court judgment in Vijaya Kumari S versus Union of India.
And it's a case that pulls you right in because it's built around, well, an absolute nightmare scenario for prospective parents.
I mean, just try to picture this for a second. You have spent years and a small fortune going through the whole emotional minefield of IVF.
Right, the injections, the procedures, everything.
And you finally get there. You have successfully frozen embryos, ready for a surrogate. You are standing right on the edge of becoming a parent.
And then, literally overnight, a new law drops, the Surrogacy Act of 2021.
And it says, sorry, you're too old. It brought in these really strict age caps, 50 for women, 55 for men.
So these couples, with their embryos already created and waiting, were suddenly told they were legally barred from taking that final step.
It's just devastating, and it sets up this huge conflict.
And a massive one. On one side, you have the government arguing for child welfare.
Their argument being that older parents might pose, health risks or guardianship issues down the line.
It's an argument that, on paper, doesn't sound completely unreasonable. They want to protect the child.
But then on the other side, you have these couples fighting for what they call their vested rights.
Their whole point is, look, we started this process under the old rules. We followed the law. You can't just change the game halfway through.
Which really forces the Supreme Court to answer this fundamental question. Can a new law reach back in time and just nullify a process that had already legally started?
To fight that, the petitioners brought out the big constitutional gun, Article 21.
We often hear about that as the right to life, but here it was all about reproductive autonomy.
Exactly. It's this idea that your personal liberty, your right to decide how and if you have a family, is protected by the Constitution. It's fundamental.
The government tried to push back on that, though. They really doubled down on the child welfare argument.
They did, but the court spotted a massive logical flaw in their reasoning.
This hypocrisy argument. This was the best part of the judgment.
It was brilliant. The court essentially said, hold on a minute. You have no age limit for a woman to conceive naturally. You have no age limit for someone to adopt under Hindu law.
So why is surrogacy the only path where being 55 is suddenly a deal breaker?
And that comparison just completely dismantled the government's case. It showed the age limit for what it was, arbitrary.
Right. If the goal is truly child welfare, that logic should apply everywhere, not just be targeted at surrogacy.
But the case didn't just turn on that. It actually came down to a question of biology. The court had to figure out, when does surrogacy actually begin?
This is what you might call the Embryo Test. The government argued that the process only starts when you hire the surrogate mother.
And since these couples hadn't hired one yet, the government's position was, tough luck, the new law applies.
But that just ignores the reality of IVF. The court was really clear on this. It defined stage A, the ovarian stimulation, the fertilization, the freezing of the embryo.
The court said once you've completed that, once you have that frozen embryo, the process has absolutely commenced. The hardest part is done.
And that biological fact became a legal shield. This is where the whole idea of a vested right comes in.
Because they had created those embryos before the law changed on January 25, 2022, the court ruled they had a crystallized right to see it through.
Justice Viswanathan had a fantastic analogy for this. He said applying the new law here was like shifting the goalposts while the game is being played.
It's perfect. You can't let a team play the first half and then at halftime announce new rules that make it impossible for them to win.
And that's a great way to understand retrospectivity.
Yeah.
Unless a law explicitly states it applies backward, which this one did not, it can't destroy rights that already exist.
You know, there's a legal distinction here between a mere hope, what lawyers call SPEEVs, and a vested right.
So if these couples had just been thinking about surrogacy,
the new law would have stopped them, absolutely. But because they took those concrete medical steps, they moved from just hoping for a child to having a legal right to continue the process.
the practical takeaway from all of this is almost, bureaucratic. Documentation is everything.
It really is. The date on that medical record, the day those embryos were frozen, is what saved their chance to have a family. It shows that facts and dates are what matter in court.
It's a powerful statement that a new law, even one meant to protect welfare, can't just steamroll the established constitutional rights of citizens.
It's comforting, for sure. But it does leave us with a pretty chilling thought to consider.
Right. The court rejected the age limit partly because it was inconsistent. It didn't apply to natural conception.
So here's the provocative question. If the government's main argument was child welfare, What stops them from trying to regulate the age for natural conception next?
If 55 is too old for a surrogate, why isn't it too old for nature? That is a terrifying thought to chew on.
It really is.
We'll leave you with that one. Thanks for joining us on this deep dive.
See you next time.